Hi, this is Kimberly. This is the third and final part of Day 5, vigorous testimony. First, they'll play for the court the December 11th, 2017 jailhouse phone calls between the the lovebirds, Chris McNabb and Courtney Bell. Next, Beau Alexander, who's the final witness for the state, finishes up his testimony, and then yada yada yada. I don't want to tell you how the rest of the day proceeds. It's not that it's that exciting, quite the contrary. Just try to stay awake for it. I do hope Your Honor supplied them all with a gift card to the closest liquor store or something for all of their trouble and all of this evidence that was just, tumbling at them. Or for those that don't drink, a voucher for a nice turkey would be appropriate. Oh, I don't think they can allow gift cards and such. Well, I hope they've been seeing to it that they are well equipped with nice snacks and lunches, if you know what I mean. It's been a long Monday in the courtroom, and although doubt has been cast above Chris and Shit 2.0, nothing concrete declares he injured and murdered his 5-pound premature newborn daughter, Kalia Claire McNabb. Chris McNabb and Courtney Bell are being tried jointly in connection with the passing of their daughter by precipitous force injury. They were slapped with a multitude of charges based on a hunch by the Newton County DA and lead investigator. I'm just curious, did they honestly look at anyone else, entertain the idea? I wonder. So, for Day 5, this is how it went. First up was Courtney Gail Morris Malcolm Moss.
And state your name for the record. Courtney Gail Morris Malcolm Moss.
She testified that Jordan Headcrack Izzo texted her off and on the night before and the morning of that baby Kalia, quote-unquote, went missing. You see, on October 6th, Courtney Gail Morris Malcolm Moss, she posted this picture that you see, and she's got her hair in braids and it's kind of greenish blue, and apparently that intrigued dumb fuck. And he apparently has no self-control, and he just had to text her. Next up was the seemingly gentle soul, Matt Lester. Well, that's how he presented himself. It appears being locked up and being called to testify in Newton County's most notorious gossip event fostered him to want to be a upstanding and standing right young man. You know what I mean. You know what I mean? You know what I mean? Prison Shit 2.0 says, you know what I mean? You know what I mean? I was scared. Anyway, Matt Lester testified that his ass was beat, and it was beat good. From the living room, carried out some tumbles and somersaults through the hall, halfway back up the hall, to which he was tossed out like a bag of potatoes, and then forcibly launched off of the porch, at which time he was capable enough to gather himself together enough to run screaming and crying and scaring the neighbors, and one kind soul allowed him the use of his cell phone. Thenceforth, he called the law to report that he had been beat up, roughed up, blasted, attacked, pummeled, clobbered, thumped, had his ass kicked, spanked, taken a flogging, thrashed, whooped, trounced on, and whacked, punched with Mr. Headcrack Izzo's brass knuckles. Brass knuckles add a big-ass wallop to your punch. And no thank you, I don't need an ambulance, he said. I just wanted to make a report. Later that evening, with blood spewing out of his scalp, he passed out and scared his parents. They was scared. And they hastily and without delay had a fucking urgent hospital wagon ambulance dispatched to the house. And then Mr. Kidd, dear me, what a character Shane Kidd is. Here, let me imitate him. Nope. With my arms crossed over my chest, all hostile-like. I just recommend watching his testimony again. I found it fascinating. I don't even know how many times I watched it. It's quite entertaining. He claims to hold the key to this case because he claims to have been texting with Mr. McNabb, Jordan Headcrack Izzo, or was it Izzy, the morning Kalia was stated missing. But this was supposedly during the time he said he was night-night. But there's no proof. Just his word against the other word. But again, how does that mean? Even if it were true, even if they could prove that beyond a shadow of a doubt, how does that mean that Christopher McNabb murdered his daughter? It doesn't. And what is the motive? I mean, I guess you could say he has a bad temper and she was crying or something, but you don't know. There's like no clear motive, and there's no way of saying, boom, he did it. Then there's this thing where a girl claims he told that Shane Kidd told her he was responsible for baby Kalia. That is until he confronted her and scared her. She was scared and had her retract her statement. Right there at that house party they were at. The meth house party. They were all methed up. Now y'all, please tell me, is Shane Kidd a liar pants? Or is he telling the truth? That's one reason I keep watching it over and over. I'm trying to figure out if he's lying. And I can't. Mr. Kidd stated that about 7:41, he just happens to remember that time even though everything was deleted on both sides supposedly, that at 7:41 on October 7th, 2017, McNabb messaged him and asked where he was and said he was, quote, wigging and tripping, end quote. Wigging and tripping is what he said in court, and that it was essential to get the fuck out of the house, out of the trailer. He's like, I got to get the fuck out of here. I'm wigging and tripping, man. And lastly, Jeff Alexander's son, Beau, was the final witness for the day on day 5. He's special investigator for the DA, and he doesn't like it when people talk about how Jeff Alexander is his daddy. It embarrasses him. So leave it to McNabb's attorney to bring it up. He's been throwing baby tantrums all day and twice asked for a mistrial. He had nothing to lose. He was just throwing shit out like a bowling ball. So, yes, Beau Alexander, if I didn't state it clearly, he's the Newton County, Georgia DA's office special investigator and was the final witness for the state for this trial. So we're still in the middle of his testimony, and we ended with, he's still up on the stand, but they played the first jailhouse call from October 2017 between the jailbirds. Lovebirds is played in court. Now and then Miss Zahn was organizing all of her papers during all of Mr. Alexander's testimony. It was nerve-wracking, it was. And that was the end of part 2. So now in part 3, I already told y'all at the beginning, so never mind. So in closing, but before we launch ourselves into the courtroom, as a reward for sticking with the rest of the day in court, you will see 2 bits of news that I have found on 2 of the casted characters of the soap opera As the Mobile Home Park Wheels Turn. Not necessarily of episode 27, that was what I was going to say. But we are at episode 27. You will see 2 bits of news that I found on casted characters, if you know what I mean. You don't. You know what I mean? You know what I mean? Good God Almighty, son. You know what I mean? Much love and peace. Thank you for listening.
You're breaking my fucking heart, Daddy.
I want some what?
D-I-K-K, Daddy. Dick Daddy.
And what does he respond?
I want my car. Why you want to be mean to me and mad at me? We are supposed to stick together and work together as a fucking family. So go and don't be a daddy anymore. It's okay, I'm strong. I'll make it without you.
Doesn't she say that's all you care about is that effing car?
Yes.
Is it fair to say that Courtney is pretty insistent on making this situation work despite whatever the Bells may think of him and whatever he may think of the Bells?
Yes.
I'm telling you the truth, Courtney. I didn't do it, baby. Can you stop baby too, goddammit?
I'd like to play States 132, and I have transcripts as well for this one. Okay.
What is the date of this jail call?
This is gonna be December 11th, 2017 at 1:16 p.m.
This call will be recorded and subject to monitoring at any time. Please enter your personal ID and subject to monitoring at any time. You may begin speaking now.
Oh. Hey. You doing? What?
Driving.
What?
Driving.
Driving. Whose car are you driving? Huh?
My car.
You running around Josh?
Josh is walked up with you.
What?
Josh is in there with you. Her my license doesn't matter.
You sure did replace me real quick, you know it.
Baby, I didn't replace you. You killed my daughter.
I can't believe you think that shit though.
When it went out.
Man, that was my daughter too, Courtney. Do you not realize that?
What else happened then?
Babe.
Who else would have did that shit?
I don't know, but whoever did it,
Her head and face would be on repair.
Listen, baby, no it's not. You can get through this, baby. Please don't break down like this. You got to listen to me. Listen to me, man. I know I did a lot of fucking shit, Courtney. I know I did a lot of fucked up shit. And I wouldn't kill our baby. I would not do that. You hear me? I told you this.
I hear you, but I don't know what else to fucking think.
Baby, I was fucking scared. That's why I ran. I was scared. Kim scared me, man.
I said I got proof you did this, and the clerk of court said you signed a piece of paper admitting it.
I didn't sign no piece of paper admitting nothing. That's a fucking lie, Courtney. These folks are lying to you, baby. They're lying to you. They're trying to get in your fucking head. I ain't signed nothing. I ain't signed shit. I ain't put my name on nothing. Baby, these folks came and took my hair out my head. They swallowed my mouth. They're trying to DNA test me because they think Rissa ain't mine and all this type of shit.
They've already proved Rissa and Kalia's hers.
I know they're mine. I know that. I told them they didn't have to do it. I know. Courtney, I didn't fucking do this shit, baby.
Then I wouldn't get it. You didn't even go to sleep.
Yes, I did. Why are you saying I didn't go to sleep? Why are you
Just screenshot.
I did not talk to that girl no more after I blocked her. I blocked her before you went to bed. I told you I was blocking her. I did not unblock that girl. What?
You talked to her.
No, I didn't.
9:46 that morning.
No, I did not. I'm telling you, I did not speak to that girl. I was fucking asleep, Courtney.
You got screenshots.
I don't care what she's got. Somebody must have hacked my shit. You act like that takes hacking. I didn't do it, baby. I swear to God on our fucking relationship on Clarissa, I didn't fucking do it.
Don't do
God
that.
damn it, I'm hurting too. I'm hurting too. I can't even fucking sleep. I take fucking sleeping medication and can't even sleep.
I don't sleep.
God damn it, I don't either. I don't sleep either, baby. This is fucking killing me. Do you not understand? This is so fucking loving. That was my baby too. I didn't fucking do this shit. Man, I love you so much, but it hurt me so bad that you fucking think that I did this shit. And you turned it back on me. I don't know either. But why you gotta fucking turn on me like this, Courtney?
I had turned on you, but there's no evidence. There's no anything else.
What evidence could they possibly have? I put her to sleep. If they're saying they got my DNA, I'm her fucking daddy. I'm her fucking father, Courtney. She's supposed to have my DNA on her. I was her daddy. I fed her. I put her to fucking sleep. job. Man, I love you so fucking much. I miss you so bad. I miss you too. I miss my baby. I miss her too. Gotta think to yourself, Courtney, why the fuck would I do something like that? You know it's been I know, you gotta hear that. I can't get her back. Why ain't you going to rehab? They want you to go to rehab. I'm not starting myself in somewhere. Baby, are you just gonna let Clarissa stay in there? My dad's getting her on the 14th. Don't take that shit. Are you sure? Yeah. I was trying to get my mama to get her because I heard they took her from Tim. I didn't think they was gonna give her back. If Tim's gonna get her, if Tim's getting her, then I ain't gonna fucking try to get mama to push it. I'll let Tim have her. I swear I will. I don't want my daddy lost in that system. You know how I feel about that shit. My dad's gonna get her and then I'll be able to sign my rights over to her. Baby, I love you so fucking much. Please, man, look. What the fuck do I gotta do, man? I need you. I need you. This is fucking killing me, Courtney. I know you didn't. No. Because I'm telling you. I'm telling you I didn't fucking do it, Courtney. I swear to fucking God I didn't do it. I don't know who did it. If I knew, I would tell them. I did not do this. You can't, I don't see how you can possibly fucking believe that I would do something like that. I'm not capable of that, you know. I know. There was an accidental recording like on somebody's Facebook voicemail of you and St. Kid in the woods trying to figure out what to do with her. Bullshit! What the fuck are you talking, baby? You can't, have you heard it? Fuck no, you ain't heard it, because it ain't fucking true. It ain't. It ain't fuck. I don't talk to them no more. I don't even call my lawyer anymore. I'm not communicating with them. They're not gonna fucking arrest me for something I ain't done. They're not going to, because you didn't fucking do it. I told them folks time and time and time again, I know for a fact that she didn't fucking do it. I know you didn't do it. I could never believe that you did it. Even if they were telling me that they had evidence, I don't give a fuck. I know you wouldn't do that. Just like you should know I wouldn't fucking do it, Courtney. You should know this. I love my babies, Courtney. I love my babies. All three of y'all. You know that. I know I did shit that I shouldn't have been doing, Courtney. That's fucking dope, man. You know that dope does me like that. That dope fucks my head up, but it didn't fuck my head up bad enough to do some shit like that, Courtney. You know that. Why would I have came back? Courtney, why would I have came the fuck back home? Baby, you know how fucking scared of police I am. You know. I told you when I went looking for her. Why did you run when they found her dead? Because Kim, baby, she fucking scared me. I was already scared. Because the motherfucker was goddamn trying to blame it on me from the fucking beginning. I told you when we left out of interrogation, that man was trying to put this shit on me from the get-go, Courtney. He was trying to put it on me from the get-go. When Kim called, I got fucking scared. I was scared, Courtney. I'm goddamn charged with some fucked up shit. It's so bad that they're keeping me in the hole. I can't even go to population. They won't even let me. I'm stuck. 24 hours a fucking day, I'm in the hole, Courtney. I'm goddamn constantly fucking thinking about what you're doing, because I miss you so goddamn bad, and motherfuckers are coming in here and telling me shit, and I don't know what the fuck to think. I need you, man. What? I ain't never needed you as bad as I need you now. You hear me? God damn it, I need you, Courtney. I'll do any fucking thing you want me to do. If you goddamn just fucking be by my side. I need you so motherfucking fucking mad at you. God damn, I got $50 motherfucking dollars and I'm about to put every single goddamn dollar of it on his phone and I'm gonna fucking call you. Every fucking dollar of it. I've been trying to call you for 3 days.
I was asleep yesterday.
Well, I'm sorry. I need you, baby. You gotta fucking, goddamn, you gotta be on my side, Courtney. We need each other, don't you see that? We need each other, baby. If I would have did some shit like that, I wouldn't even be able to look you in your eyes. We created her. We made her, Courtney. I would not do that. She was my flesh and blood, baby. You know me better than that, Courtney. I know I've done things.
I know I do, but they're not showing me any fucking evidence of nothing else.
That's because they don't want to. They don't have to. They feel like they got me, so they fucking ain't worried about it. Do you remember when he told us that he wasn't gonna go to sleep? He wasn't gonna stop until he found out what happened?
Yeah.
And then right after we left, he called the search off? Do you not remember that, baby? What the fuck did that tell you? Why didn't they find her in those fucking woods that day when they were looking? Why did they take...
that black dude Q said because she wasn't in there and he said something about a creek and a bridge. And they wouldn't tell me nothing else.
Who?
The Q dude, his name Q.
I don't even know him. I never even met him. I don't
Well,
know
I
who
met
he
him.
is. But listen to me. Why did it take a search party of some young folks to go in them goddamn woods the next day? How did they fucking find them if the dogs couldn't find them? Somebody had her. Somebody had her, Courtney, and they took her and put her back in there. And they goddamn are trying to blame me for it. If I don't goddamn beat this case, Courtney, they're gonna kill me. You understand? I need you, goddammit. You were there with me, Courtney. You were there with me. We woke up together. She woke us up. Our daughter woke us up.
I
And
know
followed-
we woke up together, but I don't know.
I'm trying to tell you, Courtney. I'm telling you the fucking truth, man. I'm goddamn shaking like a motherfucker, man. I goddamn trying to tell you, and you got to realize that I would not fucking do that shit, Courtney. It's either me or it's the goddamn police. It's me or the police, Courtney. You're believing the fucking police over me? This is me. This is the motherfucker who worships you, man. I'm goddamn gonna roll God for you, and you know it. 60 seconds remaining. I would goddamn sell my soul for you. You know this. I would not fucking hurt you like that and hurt myself. Why would I fucking do that? Get yourself together. I'm about to put some more money on this phone. I'm about to put the whole 50 on there. I'm gonna call you, alright? You hear me? I'm about to put the whole $50 on this phone. You gonna answer the phone?
Don't put all your money on the phone.
I'm good. I done had $200 in the last 2 weeks. I'm straight. I'll just call Daddy and get some more. I don't care about that. I just want to talk to you. I need you, baby. I need you.
There are 15 seconds remaining.
I gotta put the money on the phone. It's gonna take like 5 minutes to do it, and I'm gonna call you right back, alright?
Alright. If I don't answer, I'm because I'm going to the store to get cigarettes.
I love you, beautiful. I love you. I love you so much, baby. Goodbye.
Okay, pass them to your right.
December 11.
No further questions for this witness, Judge.
Mr. Carter?
Good afternoon. You helped, Ms. Zahn, you helped gather all the Facebook records that you could find in this case. Is that fair?
That's correct.
You got as many of these. You got Jordan Crackhead Izzo. You got Jordan Crackhead Izzy. You've got as many of these accounts as you could possibly find.
Yes.
Now there is evidence that Chris McNabb on his what we call his main account, I would say would be Jordan Crackhead Izzo. Is that correct?
Yes.
Now there is evidence that he was speaking with people on October 7th, the night, October 6th and October 7th, the night and morning that Kalia went missing. Is that correct?
Yes.
The last thing he does prior to say around 9:30 to 10 is he opens up the other account, the Jordan Crackhead Izzy.
Yes.
Is that correct? And he added a profile picture on that account at approximately 5:51. Is that fair?
Sounds about right.
So something like that. And he's explained well, let me say this. I know you don't like to admit this, but this is your dad, right?
Yes.
Okay. So he admitted to Investigator Alexander from the Sheriff's Department that he had made that account because he couldn't get into his other, the Izzo account.
Yes.
Is that fair? All right. So based on that, assuming he was on Facebook and he was the one controlling that account, we know that he was active until about 5:51.
Okay.
Is that fair? I mean, in other words, based on what we've seen from that account.
As far as what we've seen on that, yes.
Okay. All right. The next activity that we have is back on the Izzo account, and that is around 9:40, 9:42. He tells Courtney Morris, "Sorry about that. I didn't mean to block you," and he tried to call.
Yes.
All right. But we also know that there was a text message from his dad about 9:30.
Yes.
Is that correct?
Yes.
And according to his statement to the other investigator, Alexander, from the Sheriff's Department, he woke up when his dad texted him to let him know he was getting money, and he checked on the girls, and they were fine.
Yes.
Is that correct? So, and we do not have any other activity on his account until 10:40 when we saw that he was talking with Courtney while he was out in the woods looking for Kalia. Is that correct?
Yes.
Okay. So, understanding that Chris and Courtney both say that they went to bed around 5:30, that they got the text at 9:30 and Chris woke up and Courtney didn't. The available information we have from Facebook and text messages are consistent with their story. Is that correct?
I'd say which ones, because I feel like the story's changed per interviews. I mean, I felt like they were back and forth, up and down.
Well, they never wavered from the fact that they were up until between 3 and 5. That I believe they said at one point, but then going back and looking at their things, they said maybe it was a little bit past 5. Is that correct?
Yes. Yes.
And they both agreed that they fell asleep sometime after 5:30.
Yes.
Is that correct? They both agreed that Chris's dad texted him at 9:30 and he woke up and got up at that time.
Yes.
Now, Chris, in this jail interview or jail call that we just heard, he says he does not recall texting or messaging Courtney Morris at 9:40, but that is consistent with him waking up around 9:33 when he got the text from his dad, checking on the girls to make sure they're okay, sitting back down, logging onto Facebook, and then telling her, "Sorry, I blocked you." That's consistent, correct?
Sure.
All right. Then there's no more activity again on his Facebook until he and Courtney Bell speak while he's in the woods about looking for the child.
Yes.
Okay. So in effect, what you've been able to find from Facebook backs up that story that they've told.
Yes.
And that story is something that she's told in the 911 call, through 3 interviews. That's the same story they've told each time.
Okay.
But you're not able to find anything about Chris McNabb trying to contact Shane Kidd under any account, under any phone number. Is that fair?
No.
Mr. Kidd did not contact you 2 weeks after this happened. It was later, it was in 2018 when he contacted you.
Yes, that's correct.
And when you say that you know people from the trailer parks and you know criminals and they like to talk to you and things like that, you're talking about you still have some snitches out. Is that fair?
I wouldn't say snitches, and I would say it. I mean, just like Shane Kidd, he's never been a CI for me. So,
He's
I mean,
never
but
looked-
he is a person that I know, and I know enough people on the street that normally if I were wanting to know something or needed something, I probably would go look for them to, hey, can you tell me what's going on?
So Shane Kidd's never looked for anything from you in return for information?
No, I've never done anything that I know that would help him or further him, I guess, in life. I mean, there's never been any kind of deal or...
You've never done anything to help him or further him in life?
No.
Okay. So within the last 3 weeks, you were trying to get in touch with him, is that right?
Yes.
And the only way you could get in touch with him is through Facebook Messenger.
Yes.
And you asked him to come into the office.
Yes.
Is that correct? And
Well, I was going through other people, because
Okay.
even with him, that's the thing, a lot of times with this messenger, it's a hit or miss. I mean, are they active? I mean, it's not like a regular pay cell phone where, hey, I'm just going to call him up, or I don't have a number like that for him.
And he was hesitant to come in because he had a probation violation, a probation warrant. Is that correct?
I would say, yeah.
Okay.
Yeah.
And you spoke with an investigator in, was it Jasper County?
Yes.
You spoke with an investigator in Jasper County who, based on your request, he had the probation officer drop the probation warrant.
Well, not exactly like that. Basically what it was is I reached out to another narcotics officer. I said, hey, you got people on the street that can find out where he is. Because for me, even with him, Shane Kidd, he might not call me. He might not come and meet me. You know, now, he might call me more than he would meet me. So my thing was, or if I go and I find him face to face, I mean, he's usually not going to lie to me to my face. He's going to say, hey, you got me. So basically I asked, hey, can you find anybody know where he's at? Couldn't locate him. And that was the extent of what I asked Jasper to do.
But based on that conversation, he did contact Shane Kidd's probation officer, and he did have the probation warrant lifted.
Well, I didn't even know if it was actually lifted at that time. He mentioned to me that he called, and I said, okay. And then he said, do you think that'll help? I said, well, I mean, I definitely, I didn't ask. And that's what I even told him. I said, hey, I'm not asking. That's, whatever you do or whatever you're doing with probation, that's up to you.
As a result of your call with the Jasper County narcotics agent, he called the probation department and asked them to lift the warrant.
Yes, that's what it sounds like.
And as soon as that happened, Shane Kidd came into the office. 2 days later.
Yes.
Okay.
Yes.
Now, when he told you back in 2018 about this contact, he didn't go into nearly as much detail as he did today. Is that fair?
No. I mean, I would say it was still just as basic detail. I mean, he told me the story. I mean, he was telling me some of the other stories that basically have been out throughout this trial. I asked him about. Nothing really seemed any different. Seemed all the same.
On the Facebook messages we saw earlier, there was a exchange between Courtney and Chris that talked about not having money, needing money. Is that correct?
Yes.
But we all know that on 9/30 on October 7th, Chris's dad, Michael, notified him that he was sending the rent money.
Yes.
So Michael and Tim, not Michael McNabb and Tim Bell, did take care of the kids. They made sure rent was paid. They made sure the kids were fed, taken care of.
Yes.
During this last jail phone call between Chris and Courtney on December 11th, Courtney mentions, they've told me that you signed a confession. You signed something saying you did it. Did you hear that on the call?
That's what it sounded like.
Nothing of that sort happened, correct?
Not that I'm aware of.
All right. There's nothing that's been in court, and this isn't something that he did and the judge has suppressed. This just didn't happen, period.
No.
Okay. And when Courtney says, I've heard that there's a recording of you and Shane out in the woods trying to figure out what to do with her. That never happened either. Is that correct?
No.
There is no evidence.
Not that I've found. I mean, I haven't seen it or heard it anywhere.
And you are helping, you're working with the other Jeff Alexander, and you're working with Ms. Zahn to prepare this case. You've never heard of any recording of Shane Kidd and Chris McNabb trying to figure out what to do with Kalia's body?
No.
To the best of your knowledge, that does not exist.
No.
That's all I have. Thank you.
Mr. Frost?
Just a couple questions, thank you, Ryan.
Mr. Alexander, you worked in narcotics for some years, correct?
Yes, sir.
You're very familiar with the meth trade around here. I think Ms. Zahn had indicated.
Yes, sir.
And would you describe that as somewhat of an epidemic in this county, or even further outside the county?
Absolutely.
And it produces a good many addicts, does it not?
Yes.
And in your experience, methamphetamine does have addictive qualities?
I believe so.
All right, thank you very much.
Ms. Zahn?
Have you ever seen where methamphetamine just jumps into somebody's system without them smoking it themselves to make that choice to get addicted?
No.
Now, with respect to the Izzy records that we were just talking about, the 551 timeline, you indicated that there were several different versions of events or timelines, I guess, throughout Mr. McNabb's 3 statements.
Yes.
And it wasn't until the second interview that Investigator Freeman confronted him with these photographs from this Izzy account that he created that show that he was updating this account at 5:51 in the morning. Is that correct?
That's correct.
And then once he's confronted with these, that's when he kind of slams his fist down in the interview and ends the interview.
Yes.
And then by the third interview, does he not sort of incorporate, oh yeah, and then I changed my Facebook profile and Courtney was there, she knew about it, so he's incorporating that now into his new timeline, isn't that correct?
Yes.
But nevertheless, at the beginning, wasn't there a timeline that they went to bed somewhere between 3 and 5 in the morning?
Yes. It was very unclear and very foggy at that beginning, at that first interview. But later, I feel as more information like this came out in that interview, the times were getting a little more clear and precise or added.
So I'm showing you this page 25 of the Izzy records, and it shows again that he added this profile picture to his Facebook page at what says 9:51 UTC, subtracting 4 hours, that'd be 5:51 in the morning. Is that correct?
That's correct.
Just shy, but just 8 minutes and 7 seconds shy of 6 o'clock in the morning. Is that correct?
Yes.
Okay. Now, at any point then in the first interview or in the second interview, when he slams his fist down, confronted with this photograph, does he ever talk about texting Courtney Morris at 9:42 that morning?
No.
Does that even appear in his third interview with Alexander? Is that in his timeline at all?
No.
In fact, you heard about that on the call where Courtney's sort of confronting him with Courtney Morris, Gail Morris has screenshots of you communicating, and he tells her no, remember I blocked her that night. You told me to block her.
Yes.
But in fact, there are records now that show that he did unblock Courtney Morris and say, my bad, I don't know what happened at 9:42.
Yes.
So the timeline where he was asleep that was supposed to be from 9:33 where the text message went to Courtney Bell, is that timeline now changing as a result of all this new evidence that's been discovered with his social media?
Absolutely.
And if you incorporate the Shane Kidd text messages at 7:41 a.m. and then within an hour that the child was missing, that really screws up his timeline, does it not?
Yes.
Thank you. Those are all the questions that I have.
Mr. Carter?
Thank you, Judge. Investigator Alexander, if you're trying to look back on something you did maybe a couple of weeks ago, you can give a general guideline of, you can probably remember what you did a couple of weeks ago as far as maybe working on this case or being at home. You could do that pretty well, right?
Yes.
But if you looked at your phone and you recall during that period of time, Ms. Zahn called you and asked you to do something, that's going to help refresh your memory as to the exact times. Is that fair?
Yes.
Now, during the first interview on October 20th, or first phone call on October 20th between Courtney and Chris says, you remember when I changed my picture on my profile picture on my phone. And she goes, yeah, I remember. Is that correct?
Yes.
Okay. That's all I have, Judge.
Mr. Frost.
No, sir, no.
Ms. Zahn?
Have you ever had your child abducted, Mr. Alexander?
Never.
If your child were abducted, would you make it a point to go to your phone and pull up the exact dates and times and minutes an hour later when the police showed up?
Absolutely.
Thank you, that's all that I have.
Mr. Carter? You may step down.
During this time, the state rests.
Okay. Ladies and gentlemen, Jerry, I'm going to go ahead and excuse you for lunch. Yes, sir?
Your Honor, at this time, I would ask the court, I'd make a motion for a directed verdict on all counts. Judge, this is a very circumstantial case that shows that two parties were together in a house where a child disappeared and was later found dead. There's no direct evidence that Christopher McNabb committed the offense directly or that he was a party to the crime. Specifically with regard to count 4, murder in the second degree, Mr. McNabb is charged with committing murder in the second degree when he caused Kalia's death while in the commission of cruelty to the children, as alleged in count 7, by causing said child under the age of 18 cruel and excessive physical pain by inflicting blunt force trauma to her head. Now, count 7 reads, with criminal negligence, Mr. McNabb caused Kalia McNabb, a child under the 18 years of age, cruel and excessive physical pain by inflicting blunt force trauma upon said child. Your Honor, there's no evidence in this case that there was any type of accident or negligence which led to the death in this case.
So you don't contend taking methamphetamine and putting yourself in a mental state is negligence when you're dealing with children?
That would if there was any evidence of that. The evidence in this case is that
I thought there was evidence of him smoking actually methamphetamine that night, continually doing methamphetamine.
There was, Your Honor.
I thought he testified on his statement that he'd even had an out-of-body experience at another time because of this use of methamphetamine.
That is correct.
That's an altered state. So would it not be negligent knowing that could happen to you to do that in the presence of a 2-week-old child that's around you?
Yes, sir. But there, again, there's no evidence that this occurred in any way other than in a violent way, other than an intentional way.
We've seen rage. You know that it's theoretically, even the defendant says this was done by somebody on meth, or a meth, in essence, fueled kind of deal.
And we don't have any evidence that that is the defendant in this case. The evidence shows that Kalia was safe, happy, fed, and sleeping like a baby on that night. Christopher McNabb was acting like a proud father. To say that something happened in the meantime, that they were negligent, just doesn't make any sense. It's either intentional or it's not. Either he did this on purpose, either he intentionally did this to the child, or he didn't.
The issue is not looking at the evidence most favorable to the defendant, is how you're arguing it. It's looking at the evidence most favorable to the non-moving party, which would in this instance would be the state. And the state doesn't concede anything of what you're saying.
I understand.
And as I've already indicated to you, there is a negligence that the jury could find. They might find him not guilty of malice murder, seeing it's not intentional at all, felony murder, seeing that none of that's intentional, but find him guilty of murder in the second degree because of negligence for doing methamphetamine and getting in an enraged state.
I understand.
For some reason. So I would deny your motions on those grounds.
Yes, sir.
Anything else?
Not for me, Your Honor.
Mr. Frost.
Judge, I would make the same motion. I believe the state has failed to meet its prima facie case against my client. I understand already how the court feels about the negligence issue. As it pertains to Ms. Bell, the definition for criminal negligence is obviously that there be willful, wanton, and or reckless disregard for others. In other words, action so severe that it was almost inevitable that something like this would happen. In this case, the evidence that has been presented has been largely well, largely against the other defendant, Mr. McNabb, that he was almost an intervening and separate entity that came in, and under any circumstances, this would have ended up like that. There's nothing that has been stated that rises to the level of absolute willful and wanton behavior that would have all but made sure this came out. The only thing that really has come out to that level is allegations that someone, whether it be Mr. McNabb or someone else, came out of nowhere, broke whatever chain of events was going to happen, and performed this horrendous and heinous act against this child, as well as to count 3, and that would be for counts 2, which obviously if count 2 fails, count 1 has to fail. As to count 3, Judge, this is that she provide proper parental care, and that she failed to do so by giving adequate supervision. She was in the house, she was asleep, she'd been up with the baby according to the statements that came in. Even according to her defendant's, her co-defendant's statements, she was asleep. There's no indication this was, as someone described, some meth-induced 24-hour sleep. She had been up at as late as 5:30, and Mr. McNabb, by his own reckoning, was up at 9:30 when his father called to let him know that he had sent a check. 4 hours is, I would think, is very reasonable. If a parent can get 4 hours with a newborn, they're in high cotton, as we might say. But certainly nothing else would have been lacking in parental care at that time to support the contributing to a deprivation of a minor. And that would be our argument, Judge. We'd ask that you grant the directed verdict as to those counts, all counts.
Okay, as I've already ruled, the fundamental principle of law is that the evidence has to be looked at in the light most favorable to the non-moving party. And I find your argument to me is a total defense argument for me to look at the evidence in the light most favorable to the defendant, which I choose by law not to do. And looking at it in the light most favorable to the state, I find there is sufficient evidence to go to the jury on each of these issues. And I deny the motions. Is there anything further required on those motions by anybody?
No, sir.
Now, where are we in the case? The state has rested. I need to get some timing issues figured out.
Your Honor, I do not intend to call any witnesses, and I do not intend to call Mr. McNabb.
Okay.
I would make the same announcement for our side.
Well, then, be seated for a second. Mr. McNabb, I'm going to address you first. You've heard everything I've said out here all of the time, talking to the jurors and everything. Is that correct?
Yes, sir.
A decision on whether you testified or not testify is your decision, not your attorney's decision. Do you understand that clearly?
Yes, sir, I understand.
Have you had adequate time to talk to your attorney about the advisability of either testifying or not testifying?
Yes, I have, Your Honor.
Oh, I have to make sure from the bench that this is a freely and voluntary choice on your part after you've had adequate time to consult with your attorney. Do you feel like you've had adequate time to discuss it with your attorney?
Yes, sir, I do.
And after discussing it with your attorney and understanding clearly it's only your choice and nobody's else, and you can't be heard to complain later if things do not turn out the way you want them to turn out by saying, I wanted to testify that day, but my attorney would not allow me.
Sir, I feel like everything I could have said has already been said by myself in all interviews, so I
Okay.
don't feel like I should get on the stand
That's
because
fine.
I've conveyed everything I've wanted to say.
I just want to make sure you have a clear understanding of everything, and this is your choice.
Yes, sir.
Okay. Ms. Bell, I'm going to, in essence, tell you the same thing and ask you the same questions. You understand what your rights are?
Yes, I do.
You understand that you're the only one that can make the decision about whether you testify or not testify?
Absolutely.
You understand your attorneys may advise you, but they can't order you or tell you.
Yes, sir.
you understand that if convicted, you will not be heard to complain later, or that you just didn't get your opportunity to testify.
Right.
Okay. Now, is the decision not to testify your decision?
It is.
Is it freely and voluntarily entered into?
Yes.
Okay, then, is there any further advisements anybody wishes me to do on the record?
No, sir, Your Honor.
No, Your Honor.
Let's turn next to our charges, and hold our charge conference. And make sure. Turn to the state's request to charge first. Now, typically, I'm just gonna tell you what I'm gonna do, and y'all tell me if you wanna make any objections on the record. Their number one charge is simply a definition of the crime of malice murder, which the court will give. Number two is a definition of motive, which the court will give. Number three is a definition of felony murder, which the court will give. Next, on 4 is a definition of battery, which the court will give. Cruelty to children in the first degree is number 5, which the court will give. Number 6 is felony murder, which the court will give a definition of. Number 7 is murder in the second degree, which the court will give. Number 8 is cruelty to children in the second degree, which the court will give. Number 9 is a definition of criminal negligence, which the court will give. Number 10 is considering the death of another, which the court will give. Number 12 is contributing to the delinquency or dependency of a minor, which the court will give.
Judge, I was going to ask, could you, for state's number 9, criminal negligence, could you please let the jury know that that only applies to count 4, the second degree murder count?
Yes. I don't have all this in front of me right now, but is negligence talked about in the other counts, not one or, so it's not at all on, so it's only cruelty to children in the second degree, y'all are saying?
Yeah.
Okay, that's fine.
And murder, second degree murder.
Right, but also cruelty to children in
Yeah.
second degree. I've already said about 10 and 11. Number 12 is on intent, which the court will give. 13 is on expert witnesses, which the court will give. 14 is on single witness and corroboration, which the court will give. Number 15 is the statement by one defendant at a joint trial, which the court will again give. I've given it several times. Number 16, y'all have got it real detail about stipulations, but I don't know we need all of that. If I just tell them in the standard evidence charge that it's stipulations which are agreed to by counsel, so I will not give you number 16. 17 is on direct and circumstantial evidence, which the court's going to give the pattern on. 18 is on credibility of witnesses, which the court will give the pattern on. 19 is on prior difficulties. Are you only talking about prior difficulties between?
I'm just withdrawing that one.
You're withdrawing that, okay? Number 20 is the limiting instructions. Was that for the prior difficulties?
Yes, Your Honor. Oh, no, that was for the, when we were reading the statements, I believe.
Okay, then I will give number 20 on limiting instructions. I'm giving them 21 on sympathy, 22 on the responsibility for sentencing. And I see that there have been additional supplemental charges given. I've got down 20, I've got 2 23s, I guess, but you really mean 22. What was the last one you had? You had a 22, so your 23, Ms. Stone, would be intoxication, voluntary, no excuse for a crime, which the court will give. A new number 24 is being withdrawn. But I'll ask just to make sure, anybody raising the issue of venue? Anybody on the defense side see the necessity for giving a venue charge?
Yes.
Okay, so I will not give 24. That concludes the state's charges, am I right?
Well, we actually filed an additional supplement on 25, which is it's the venue charge that we meant to submit in 24, but it was not correct. It was filed this morning, but it essentially says that homicide is proven, venue is either where the wound was inflicted that caused the death, or that cannot be determined, then where the body was found. And here, we don't have specific evidence whether the child was killed in the trailer, outside the trailer. I certainly don't think anybody's contending that somebody took the child into another county and then buried it here. But to be on the safe side, I just wanted to point out to the jury that because the body was found here in Newton County, venue lies here, even though we don't know.
Well, my first comment would be on either defense attorney. Are y'all planning to argue that point she's just making?
I do not have any evidence the child died anywhere other than Newton County.
So you would
not
argue to the
that.
jury?
That's correct.
Mr. Frost?
No, Your Honor.
So you're gonna inject something into the trial that's not
No,
there?
Judge, I just wanted to cover the bases to make sure.
Hey, if you want it, I will give it. But if nobody's even talking about it, do you actually think a juror's gonna get back there and say to themselves, you know,
No, Your Honor.
they could have taken the child somewhere else and killed it and then brought it back, so that's gonna be the impediment to me. But if you want me to give it, I will give it. Which one do you want me to do?
I would prefer that you give it, Judge.
I'll give it at Mrs. Zahn's insistence.
Thank you.
Turning now to Mr. McNabb's charges. Let's turn to number 1, which is grave suspicion. I'll work it into the reasonable doubt charge. Your number 2 is on credibility of witnesses, which the court's going to give the pattern charge. Your number 3 is on the impeachment of witnesses, which the court will give. Number 4 is on prior statements. I will give. 5, I've already indicated I'm going to give sympathy charge. I will give you number 6, but I'm really probably going to give Mr. Frost because it's more expansive. I will not give the new charge on that, but I'll give the one Mr. Frost is given. Number 7 is mere presence, which the court will give. And number 8 is mere association, which the court will give. Now, are there any comments made about Mr. McNabb's requested charge?
Mr. Chair.
Ms. Zahn, from your side?
Just on number 4, prior statements, are you giving the pattern or are you giving that?
I think we give the pattern charge. Is that what we've got in there, Mr. Decker? Yeah. We got the pattern charge
Okay, thank you.
that I would give, and we'll check it again at lunch. Turning next to the defendant's bail charges. Number 1 is murder in the second degree. I've already indicated I'm giving that one. Cruelty to children, second degree is number 2, which I'm giving the definition. Number 3 is the indictment and plea not being evidence, and the court's going to already give the pattern charge on that. Number 4 is that the court has no interest in the case, which the court will give. I'm going to give the pattern charge on the presumption of innocence, burden of proof, and reasonable doubt that you're asking for, number 5. Number 6 is on intent. The court's going to give the pattern charge on that. Number 7 is on motive, which the court's already indicated it's giving us a pattern charge. Number 8 is no presumption of criminal intent, which the court's going to give. And number 9 we need to talk about. I find all that's confusing, Mr. Frost, because of the particular circumstances in this case.
Yes, sir.
I think the general charge on intent covers the principles of law adequately. The knowledge charge, you see it very readily in a drug possession case. And Judge Benton had a case that got reversed because he would not give the charge. The defendant was charged with possession of a pill, which is a Schedule II drug, let's say. His defense was that he'd gotten it from his mama and thought it was aspirin. And so the Supreme Court of the Court of Appeals ruled that you needed to give this charge in that instance to make sure they understood, the juries did, what the defense of the defendant was, that he had no knowledge that the pill he had was the specific controlled substance. He thought it was aspirin, and they had to figure out the credibility of that. We've got a case that, for your client, revolves around the negligence of the environment that had been created and her specific knowledge that it was a dangerous environment because of the previous actions of McNabb against her and the use of methamphetamine. So to me, it's kind of clouding the whole issue. If I give the charge, and you can easily stand up and look at the jurors and say, you just wait till that judge says she's got to have actual knowledge a murder is going to be committed in order for you to find her guilty. I'm not so certain that's true. I think it's the environment through her negligence that she creates. In a corollary, I'm going to tell you, is where negligence is really coming up so often with all attorneys, and that's in the civil arena of car accidents. It'd be almost as if saying, well, a person has the knowledge that a car accident's going to happen before you can find them guilty of negligence in this way, and that's just not the truth. It's the existence of the state that's created through your negligence that you can be found culpable for later. Is there anything, Ms. On, that you want to say contrary to what I'm saying, or?
No, Judge, but I note at the top of the charge, it's talking about knowing and intentionally. So I think knowledge is only applicable in an intentional crime, where she's charged with an intentional crime as opposed to negligence.
Okay, that's a much better, shorter way of saying what I rambled on about 10 minutes of saying. So I would not give your number 9, finding that the intent charge covers the principle adequately and due to the peculiar circumstances of this case.
We're gonna stick just with the intent?
The pattern charge on intent,
Okay.
which says she has to intentionally intend to commit the act.
Okay, that's fine. I mean, I would object for the record. But
Okay? I've already indicated I'm going to give number 10 and number 11. I've already indicated I'm going to give number 12 on grave suspicion. I'm going to give the pattern charge on multiple defendants. I've already indicated I'm giving this charge on the defendant's election not to testify. I'm going to give the charge on direct circumstantial evidence, as I've said, in number 15.
Judge, I would ask that you give this charge. The state doesn't have the last paragraph where it says you'd be authorized to convict only if it excludes every other reasonable hypothesis.
The pattern charge does include that, Mr. Decker. Did you put in the pattern charge on this?
Mr. Frost's 2013 charge is the pattern for 2013.
Is that the one you put in?
Yes, sir. They were all in there, but I moved the other two.
We typically just go to the pattern charge.
Right.
And get it, and that would have been in there.
Yes, sir.
And I, again, make a note to recheck that during lunch. Number 16, I've already given, indicated I'm going to give a charge on impeachment. 17 is on credibility witnesses. I've already indicated I'm going to give. Number 18, I've already indicated I'm going to give just statement by one defendant in a joint trial. I guess I will give number 19. Immunity or leniency granted the witness.
I guess he's referring to Shane Kidd, and I have no objection, Judge.
Okay, then I'll give you number 20, but this is Mr. Frost who's asking for it. I've already indicated I'm going to give a prior statement charge. Now we come into your number 22, which is a very lengthy charge on the statement of the defendant. There's not been any issue in this case that any statement given was not freely and voluntarily given. Are you asking that I give all this so that you can argue to the jury that the statement she gave was not freely and voluntarily given?
I'm not gonna be making that argument at all.
Well, if you're not making the argument, then why would I charge them on issues of law?
That's fine.
So it's fine if I do not give it.
Yeah, yes, sir.
Okay, I will not give you number 22. Number 23 is on expert witnesses, which the court's going to give the standard charge.
I'm sorry. They're just, the only argument, I just want to make sure I say this before I actually get up and close and argue it, is I do plan to mention that there was times in one of her statements, I believe it was second or third one, where she says numerous times, I'm freezing, I'm blue, I really want to go, I just want to go, I just want to go, over and over and over and over. Now, I don't plan to say that anything other than, yet she stayed. Despite.
You can say all of
I
that.
just want to make sure.
Charge 22 goes to the freeness, that's
Voluntariness, freedom.
voluntariness.
Yes, I understand.
Freely given a statement, that's what I'm saying.
Correct, yes.
Okay, so you can argue that, no problem. That
Thank you,
concludes, Mr. Frost's charge. Any comments anybody wants to make about that?
No, sir.
No, Your Honor.
And I didn't ask when I finished the state's charge, are there any comments anybody wants to make about the state's charges?
No, sir.
Anything else we need to discuss out here?
Judge, if your clerk gets this together, your charge together in written form before 1:45, can he email a copy to us? We'll just have.
I'm not gonna have it together before 1:45. I spent all my time taking that charge and fly specking it over and over again while y'all are giving closing statements. I'd already been asked by the media if I'd just give them a copy of my charge, and I say no, because I write all over it, you know, and make notes. And like I say, I've caught so many things during the closings that I thought I'd caught before, in reality had not. So, no. But I'll give you one after I conclude the charge, if that's possible. So for any other time, but you know.
Yes, sir.
And I'll take a recess after the jury goes out for you to fly spec what I'll give you at that point in time to see if you want to make further objections on the record.
Yes, sir. The other thing I would ask, we never really spoke about it. In fact, Mr. Frost and I never really spoke about it, but I've just been going first the whole time.
Mm-hmm.
I would prefer that Mr. Frost give his closing, then I give mine. I have the most serious charge, and I don't know how the court is supposed to make that decision when we can't agree. Mr. Frost says he doesn't want to do that.
I'm not going to allow it. We're going to do the same order we've been doing all along. I'm not going to shift the order now. Y'all should have said something a lot earlier about how you wanted to proceed, because I would have alternated the whole time. And whoever made the opening statement, you know, I've got to be fair to both sides. And you're telling me now, well, you know, I want to shift it at this 12th hour. It shouldn't change anything. Y'all both have to speak prior to the state speaking, unless you're going to use both sides of yours. You're not, you're going to only use your. So, utilizing my discretion, we're going to keep the same order.
Yes, sir.
Anything else?
Just with respect to time, it's my understanding that we have more than an hour in a capital case if required.
Yes, I don't know. You're welcome to research, because there's mixed findings. The statutory law says one thing and the uniform rules say another thing. So what takes place? The statutory law or the uniform rules? I would assume it's the statutory law.
It's always been my understanding, Judge, that there was 2 hours afforded, but I'll get the research. And I don't know that I'm not threatening that it would be 2 hours, but I do have to respond to two different attorneys, and there are two different defenses and two different theories of guilt in terms, so it might take longer than an hour. And I imagine they're both going to be pretty lengthy closings as well.
Well, what are we going to do? Because you're indicating to me that the jury wouldn't even get the case till 6 o'clock today sometime. By what you're saying,
I
2
speak very
o'clock
fast.
2 o'clock is when we're coming back. So if you take an hour, you take an hour, you take an hour, that's 5 o'clock. And then the charge itself is going to take a good 30 minutes. So and that's just if everything runs smoothly and there's no problems. So we got a choice to make. And I might leave it up to the jury whether they want to go ahead today, even if we're going to tonight, or whether they want to recess for today and have closing arguments tomorrow morning, where we can do it all at one time. What do y'all think?
I'm happy with whatever the jury decides. I can do it today. I see benefit in waiting until tomorrow morning so that we have the full day to do it. But I think if we can get the arguments done and then ask the jury, you know, whether they want to stay and deliberate or just start deliberating in the morning, that would be fine as well. So I'm very flexible.
You say two things, because I would have to know that before the arguments were done. I can't wait till the arguments are done and then put it to them.
I think that was a long way of saying I'm flexible.
Okay. Mr. Frost?
I would, I'm not partial one way or the other. On the one hand, I'm very eager to
Y'all be ready to go. I'll bring the jurors out after lunch, and my first comments to them would be the timing issue of whether they wanted to go today which meant they might not even get the case till 6 o'clock. Might be earlier, but I can't predict that. And I would want them to start deliberating, but then that's going to put us into the supper hour. You know, what do you do? I mean, this is crazy. If I had a preference, I would want them to all say, "Oh, Judge, we're happy to come back tomorrow morning." And that way it'd be a lot better for everybody. Y'all wear me out. I know I look like I'm a young, vigorous man. It's not true. I'm aging by the minute. So, does everybody know what we're talking about?
Yes, sir.
Okay, it's 1 o'clock. We'll be back at 1:45. Let's go back on the record. The state's submission of a charge, of course, let me see if I can lay my hands on it. Use the term intoxicants. Typically people think about intoxication with alcohol. This is more being under the influence of drugs. So I was thinking about, would you staple together this thing again? I was thinking that was the old one. Because the pattern charge is on intoxication, which, as I've already indicated, is about alcohol. So I was going to have it be, Georgia law provides that voluntary intoxication or being under the influence of drugs shall not be an excuse for any criminal act. It further provides that if a person's mind, when not affected by drugs, is capable of distinguishing between right and wrong, as well as of reasoning and acting rationally, and the person voluntarily deprives himself or herself of reason by consuming drugs and commits a criminal act while under the influence of such drugs, the person is criminally responsible for such acts to the same extent as if the person were not under the influence of the drugs. Whether or not the defendant in this case was voluntarily under the influence of drugs at or during the time alleged in this indictment is a matter solely for you, the jury, to determine. Is that adequate to everybody?
Yes.
Yes, sir.
Yes, sir.
Okay. Don't think we on the record in front of the jury talked about y'all's resting your cases and the defendant's not testifying. So when the jurors are first brought out, then I'm going to allow y'all, I'm going to turn and ask for you to present your defenses and you'll tell me, you know, we're resting. At the time, I'm going to turn to the jury and realize that I think that's what you were talking about, Mr. Carter. We have three options. One is to try to cram everything in today, and then let them start deliberating. Two is just recess it until tomorrow to do everything, or probably the third one is to do the closing statements today. Then send them home and me do the charge of the court tomorrow morning when they first get back. What do y'all think? Anybody?
That is what I was thinking.
I don't like option number 3, Judge. I mean, I'd rather them be charged right after the closings and go into arguments. But
With all this evidence, you think that somehow they can wade through all this evidence that's been submitted, thousands upon pages of the Facebook notebooks, and look at all that, hours of video testimony. Well, I'm going to leave it up to the jurors on those three options, because I think the better option is that one I just said, the third option, because we get it done, but they can't deliberate yet until they get the closing charge tomorrow morning, and have the whole day to deliberate, because the charge won't take 30 minutes or 45 minutes, and then they would have that. Mr. Frost?
Yes, sir. Because of that exact reason, when you discuss it with the jury, will you make mention that we will probably cite to some of those jury charges? And I want them to understand how important it will be to be able to remember what we're saying in light of what they're going to hear from the court as far as the law and when they put them together. Because my fear is that if we don't do this in one cohesive strand, they may be, what did that guy say? And I realize that what we say in closing arguments is not evidence. However, we're going to be putting the summation together, and I'm afraid they may.
Okay, so state's opposed to me to splitting the closing charges and the charge of court, and you sound like you're opposed to that too.
Yes, sir.
Okay, so I got two opposed to it, and Mr. Carter is flexible, as he said. So he's just neutral in the matter. Okay, it's gonna be a starker choice now, without any compromise, because I'll just give them the two choices, and take the third one off the table. Is everybody ready?
Yes, sir.
Let me bring the jurors in. Everybody be seated. The state has rested its case, so I turn first to Mr. McNabb and Mr. Carter. You may present your first witness.
Your Honor, on behalf of Mr. McNabb, the defense rests.
We next turn to Ms. Bell's defense. Mr. Frost?
Your Honor, on behalf of Ms. Bell, the defense rests.
Then we consider the evidence closed at this time. There comes a time when it's real awkward for me, because with my experience and everything, I can see how things are kind of playing out. Each side is going to have extensive time to make their arguments to you. As I've stated at some other time, I can't predict when baseball games are going to end, whether it be extra innings or not. I can't predict this. Let's assume for a second that they might take all the way up to 5 or 5:30 with their closing arguments. Well, I got to give you a charge of a court right there, because they fashion their arguments a lot of time on what charges of law I'm going to give you. That'd push us up after that. And then we'd all want you to start deliberating right away. I think the better thing to do, although I hate it for y'all, I say that, but I think we'd be back tomorrow anyway, is just to release everybody today and have you reconvene tomorrow morning at 9 o'clock, where we can do it all one fell swoop. And you'll have time to look at the evidence without somebody going to sleep back there, because it's not a marathon. I want y'all to be rested and listen to everybody with a clear head, and the charge of law with a clear head. So, unless I hear some strong objection to it, we're going to recess until 9 o'clock tomorrow morning to continue. Anybody who needs to, of course this is being live streamed, so maybe your bosses are watching, but if they weren't, it'd be 5 o'clock right now for their purposes. But since they might be watching, then it doesn't matter. So again, remember my instructions. Don't discuss this case with each other or anybody else. Allow anybody to discuss it with you. Do no investigation on your own of any kind, form, or fashion. Time you arrive to get here at 9 o'clock for the reasons stated earlier. Make sure you don't let anybody talk to you about the case, that you look at social media of the case, the television of the case. It heats up about this time of the case with the media. So be extra cautious, and don't look at anything, social media, anything. Have I got your assurances on that? Everybody's nodding their head yes. You're excused until 9 a.m. tomorrow morning. I would state that I didn't really give them a choice. I use the time-worn technique by my wife. I always think I have a choice, but in reality, she's telling me what to do. And I don't even realize it when I'm sucked into it. We'll be in recess till 9 o'clock tomorrow morning.